Welcome back to Face the Jury, a podcast dedicated to medical malpractice, what it is, how to spot it, how to protect yourself and your family from becoming victims of medical malpractice. Today we have a special guest, and I caught myself saying this because I tend to say this with every guest that I introduce them as our special guest. But today is particularly special because we have the benefit of a former juror who had recently sat on one of my trials this past July, Miss Angela Banks. Welcome, Angela. Thank you for being here today.
Thank you. It's an honor to be here and be a public servant.
Well, I appreciate you making time for us, and I'm looking forward to talking to you about your juror experience. And I want to give just a little bit of background about the case in just a moment before we jump in. But before we do, tell us a little bit about yourself. Tell us your background, what you do for a living, a little bit about who you are.
Great. My name is Angela Banks. I am a forever Gwinnett County resident. I have been living in Gwinnett County for over 25 years. Proud graduate of Leadership Gwinnett here in Gwinnett County, and just a staunch champion of all the great work in Gwinnett County. Moved here to attend college, undergraduate, Clark Atlanta University. Then I went to get my graduate degree at Emory University School of Public Health. And since then, I have been working for the federal government at CDC for 25 years and am a public health champion of all the work that we do at our federal agency. Proud mother of one daughter.
Oh, congratulations. And where's your daughter in school?
Spelman College here in Atlanta, Georgia.
That's one of the competitors of Clark, right? One of the rivals?
Yes, absolutely.
Well, thank you so much for being here and sharing your time and experience with us. I want to give a little bit of background before we jump into it so our listeners kind of have some context. But about, maybe a month ago, we tried a case. I tried a case against a cardiology group and a surgical group, and the physicians involved in care for my client, Mr. Ron Yarbrough and his wife, Glenda Yarbrough. And Angela was the fortunate recipient of a juror summons commanding you to appear in court. And I always make this point during jury selection that the only time a private citizen can be commanded to do anything, law-abiding citizen can be commanded to do anything, is juror service, because it's that important that citizens come in and participate. And this was a case, again, of medical malpractice. The allegations broadly were that Ron Yarbrough was mismanaged regarding his what's called a CT calcium score. It's a test to look at your coronary arteries for blockages and plaque buildup. And the allegations were that he was mismanaged by the cardiology group and then later by the surgical group who did not get cardiac clearance before taking him back to surgery. And unfortunately for Mr. Yarbrough, he experienced a heart attack 2 days after the surgery, which everyone agreed was because he had multiple blockages in his coronary arteries that were not identified or treated. And unfortunately, after about 36 days, Mr. Yarbrough passed away from the injury to his heart. But I'm here, and Angela's been nice enough to be here with us to talk about your experience as a juror. So before we jump in too much on that, tell me when you first received your notice of jury duty, kind of what went through your mind and how you reacted.
As with any juror notification, you're like, why me? It was actually vacation time, so I actually scheduled a reset. So the reset date was July after my vacation travel, so I couldn't request a new date. So that's honestly how I was selected to return back. So that was my experience. Of course, no one wants their lives disrupted, having to sit on a jury. But once you've been selected and hear the case, you're like really honored to have served on the jury panel.
And this wasn't your first jury.
Absolutely.
Tell us just a little bit about your first experience, because that was also a medical malpractice case.
Yeah, so I actually served on another malpractice case maybe a few years ago, maybe 2 to 3 years ago. It was a medical malpractice case where the client went to Emory, East Side,
Hmm.
and went for spinal surgery,
Hmm.
and you have to lay flat. And under anesthesia, the chemicals ran into her eyes and caused legal blindness.
Hmm.
So she has a permanent disability, had cadaver eyes done, every multiple surgeries, and could never regain her vision. So it was definitely a medical error in the surgery room of Emory Eastside.
And did that result in a plaintiff's verdict or a defense verdict?
We awarded her a multimillion-dollar civil lawsuit win.
Okay, so it's interesting. We're allowed to ask you and all the jurors, potential jurors, if you've served on a jury before, what type of jury it was, if you've been the foreperson. But the way the rules work, we're really not allowed to ask you the result. And I think the reason why is because it would just be too prejudicial. If the defense learned that you'd been on a verdict in favor of the plaintiff, a jury that found in favor of the plaintiff, that would be a motivating factor to get you off the jury. So the way the rules work, we're not really allowed to know what the result was. This is the first time I've learned about that result. But so you must think that you're kind of getting selected as the medical malpractice juror in some regard. You get summoned to come to court.
Yeah.
You come to court. This is, as you mentioned, up in Gwinnett County. And just tell us about your experience. I mean, you'd been through it before, as you mentioned, but just tell us in this case about your experience. When you show up, give the listeners an idea of what it was like for you.
The experience was every time I serve on a case is very educational. You have all these medical experts that come and kind of give their subject matter expertise. So it's good to learn a lot about the specific case. So our experience as a juror was, okay, how long are we going to be here?
How disruptive is this going to be, right?
Yes, which attorney could really influence the jury on
Mm-hmm.
kind of how to make a good sound judgment. So it was a lot of back and forth with the jury because everyone came with their different opinion one way, but we left out united on our judgment. So it was a lot of reviewing medical records because you guys did a great job. Both sides did equally. But of course, your law firm, Attorney Bell, really prevailed in
Mm-hmm.
kind of how you presented the information, how you basically describe the standard of care in very plain language for us that are not legal people.
Mm-hmm.
So just us combing through all of the tons and tons of documents that were given to us in the deliberation room, a lot of nudging, how would I say, a lot of us bartering
Yeah.
and kind of agreeing to, okay, we have to leave here with a consensus. So it was a lot of that. That's why it took us a while to kind of deliberate because people came with their own prejudgments and we
Mm-hmm.
had to look at the facts. We had to look at the facts of the case. And that's what led us to awarding the Yarborough family the judgment.
I've expressed this before, how grateful we are that you reached the verdict you did, and based on the evidence and the law. I want to take it in sort of pieces in a timeline, because I think it'd be interesting for our listeners to sort of see things through your eyes during the different parts of the trial. So let's start off with when you first walk into the courtroom. Okay, you've been up in the big retaining pool, the big holding pen for all the potential jurors. Your name gets called out along with about 50 other people, and you're sent down to Judge Colvin's courtroom. Give us an idea of what's going through your mind as you walk into the courtroom. You see all these lawyers and people and suits and judge and bailiff and all that. What's going through your mind in those moments?
Honestly, it was like, don't pick me. Don't pick me. We have plans for the week. But
Yeah.
we felt like, after, when we were in the deliberation, as if we were being interviewed as a panel and didn't know the level of detail that you guys had done for pre-planning. So
Mm-hmm.
we tried to be, as I know I did, tried to be as candid as I could about the questions. But going through there, we were like, okay, it's 57 people, 50 plus. I can't remember the exact number.
Yeah.
But we were thinking, okay, we're not going to get selected because I even made it clear that I had served on a malpractice lawsuit previously.
Yep,
So I
you did.
knew I was not going to be selected. But I guess you guys saw otherwise. We saw the specific questions. There was like a lot of people sitting there asking questions.
Hmm.
And then I, in my mind, just never in my wildest dream thought I would be selected to serve on the panel.
Well, I got to tell you, you're a little bit on the fence because there were some things that some of your answers gave the plaintiff side, the patient side, some concern because I think you have some medical people in your family. I
Yeah.
think you mentioned that I believe your sister had a medical issue and
Yeah.
had received very, very good care, and so we were interested in people who had very favorable opinions about our healthcare system generally, and you seem to kind of have some of that. But you also, I believe, had an experience you shared with us where a test was not read correctly for you.
Absolutely. Yeah.
That made us think that you might be able to identify with the importance of conveying accurate information, because that was one of the issues, of course, in our case, was that a test result was not communicated accurately to the patient. He was told the test result was basically normal
Yeah.
when in fact it was grossly abnormal.
Yeah.
So we almost didn't pick you, but
Yeah.
we don't really pick people because we strike people, and then it's the people that are left that end up on the jury. So I don't get to say I want Miss Banks on my jury. We get a certain number of people that we say I don't want this person, I don't want that person, and then both sides kind of whittle the group down, and then the people who are left become our jury. So.
Yeah, actually, my sister, she actually passed away in March.
Oh,
So
I'm
she
sorry to hear
went
that.
for medical treatment at Emory. So I'm actually going through that process now.
Hmm.
And she had a colon surgery doing the ER room and transitioned as part of that. So I'm going through that process now, just trying to get legal opinion.
This sounds like this has touched a little bit of your personal life, and I'm sorry to hear about your sister. Um, I do want to ask you. So you're sitting there, and we ask questions, or I ask questions, the plaintiff side, for probably 2.5 hours, maybe close to 3 hours. What's going through your mind when we're asked? I'm particularly. I'll start with me, and then I'll move to the defense. But I'm asking all these questions about people's experiences, people's expectations about medical care. Is it like enough? Would you stop asking questions? I mentioned brutal honesty a few times, but you're sort of a captive audience. But what's going through your mind when I'm asking all these questions?
Well, I know I was trying to figure out what was the intent of asking so many specific questions
Yeah,
about medical care. And I know you guys wanted to select the best jury, but in my opinion, thought, okay, we're going on and on. Like,
yeah.
what is this about? Because, you're seeing people looking at you, taking notes, walking the room. And I did notice that you guys made sure that every person on that panel answered questions. So I did come to some sense that, you guys are being intentional about the
Hmm.
types of responses. But that was kind of what I was like, how much longer do we have? Because it was a lot of very targeted questions.
Yeah. And then you get picked.
Yeah.
And what goes through your mind when the judge announced your number and you stand up? I mean, I can still see your expression. I don't remember a big smile. I think you seemed a little resigned, a little bit like, really?
Yes, I was like, oh my God, here we go. Time for back to school. And now we're jury selection. So that's what I was thinking, like, what is the timeline for this case,
Hmm.
And once, we heard a little bit more, we kind of understood that we're just going to have to be patient and make sure that we hear both sides of the story so we can
Hmm.
make a good judgment. But overall, I think the decision went well, and you guys were pretty deliberate in kind of how you guys were selecting the jury.
I appreciate that. Do you remember anything that stands out from the defense questioning? Any different than the plaintiff's questioning? They were shorter, obviously, but anything stand out?
I think the exhibits stood out because they used a lot of your exhibits, and we felt that the jury as a whole that they just weren't prepared like you guys were.
Hmm.
We were like, they're using your exhibits. You were able to plain language it more for us, even as
Hmm.
if we were a fifth grader. You plain
Mm-hmm.
language everything, even though the terminology was pretty medical. You were victorious, I'll say, in
Mm-hmm.
kind of plain languaging everything, especially with standard of care, because that was kind of led us to the judgment. Is your
Mm-hmm.
exhibits, how you explained it, you had all your technology. Of course, there were one or two glitches on both sides,
Yeah.
but we felt that you kind of prevailed the most in
Mm-hmm.
all of your exhibits and your technology, and especially your expert witnesses.
Well, let's talk about the experts a little bit. What stands out to you now? Just to remind you that on our side we had Dr. Levy, who is the cardiologist from California and retired now, and then we had the colorectal surgeon, Dr. Stephen Cohen, out of Virginia. Talk about Dr. Levy first. What do you recall about him, and what were your impressions?
So Dr. Levy was very good and thorough with his explanation. I like that, and the panel as a whole. He was able to, again, plain language,
Mm-hmm.
kind of his expert opinion. So even though backstage, well, in the deliberation room, people talked about the cost. I really feel like it was worth it because this is a very serious case. So you want to get the best expert to kind of explain their craft to us, a jury, so that
Mm-hmm.
we can convince, about the testing, the coronary testing, the plaque buildup, all of that. So I think he was very influencing to the jury. And he gave
Mm-hmm.
good eye contact. He was able to answer the questions on both sides, even though some of them were not favorable. But he was
Mm-hmm.
able to maintain a calmness with him and explain the facts of the case.
Compare and contrast with the defense cardiologist, Dr. Sigmund. How would you compare the two?
So remind me, Dr. Sigmund, was he the one?
From Piedmont, excuse me. He was from
Yes,
Piedmont.
and he was new.
Defense called him to come in and defend Dr. Friedland.
Okay. Yeah, is that the one that's kind of new as an expert?
Yeah, this was one of his
Okay.
first time testifying.
He was not convincing at all. His testimony, because I guess you guys had given him a interview previously.
Yeah, we say his deposition, but
Yes, his
yeah.
deposition. So he
Hmm.
wasn't really convincing to us. He couldn't recall a lot of the things that he had done. And even though he was with Piedmont, it really wasn't convincing to us that he was representing their side of the
Hmm.
trial. So we weren't convinced. Again, we all said unanimously that your legal experts were far more superior
Hmm.
in presenting the case, and that perhaps the other side didn't have time to kind of meet with their medical experts. We just weren't sure. It just didn't carry the burden
Hmm.
of the case to convince us, because I think you guys countered and asked probed questions, and, he kind of flipped and flopped on his responses and
Yeah.
asked to review documents again. So we were like, he's not as credible as Dr. Levy and Dr. Cohen.
And he was cross examined. Dr. Sigmund was cross examined by my co counsel, Darren Somerville. And just to kind of refresh your memory about that. And then there was another expert, Dr. We call Dr. Cohen. He was our colorectal surgeon. And then the defense called Dr. Singh, who is their surgeon. Do you remember Dr. Singh?
I'm trying to remember Dr. Singh.
Dark hair, good looking, sort of Hollywood looking guy.
Yeah.
What were your memories about the expert testimony on those two, the colorectal surgery side?
So on the colorectal side, again, not very that convincing. Of course, had all the accolades of a renowned physician, but
Hmm.
I'm trying to recall what really stood out with Dr. Singh. And I think through the cross examination, again, didn't prove as credible to us. I know people took notes and just was like, it, not as convincing.
He had forgotten a lot of the details of the case.
Yes.
For example, I remember crossing him. He didn't know why Ron had gotten the colonoscopy. He thought
Yeah.
he had gotten it because it was just a regular surveillance one, routine, when in fact it was response to abdominal problems.
Yeah.
And then he also testified he didn't wasn't aware that Ron was type 2, was taking insulin for his diabetes. So it
Yeah.
seemed to me that he didn't know the file as well as he
Yeah.
could have.
Yeah, and that's what we recall was like, was he representing their side? Because when he was cross-examined, he couldn't recall any of the facts. So I don't know if he just came into town or what the backstory was, but not really compelling or convincing because when the facts were presented, he just didn't recall all the details of the case.
Our first witnesses were representatives from cardiovascular group. We called the head of the group, and then we called Dr. Friedland. What stands out to you? And Dr. Friedland, for the listeners, was the cardiologist, longtime cardiologist for Ron Yarbrough over almost 30 years. And the criticism against Dr. Friedland was that he did not properly inform Ron about his abnormal CT calcium score, and then didn't adequately respond when just a few weeks later, Ron's family member was reporting chest pain, chest tightness, shortness of breath. What stands out to you, Angela, about Dr. Friedland's testimony?
So what stood out to us is, I guess I would like to call it bedside manners. He has been a longtime physician for Mr. Yarbrough. And for him to, with the new electronic system, not pay attention to the results, we felt that that was a huge, major deal because it's my understanding that he receives it electronically and his communication with the nurse just did not relay well. So that letter was a pivotal piece of evidence because it gave misinformation to the family. Misinformation to the family. And his response was, well, I don't read every patient's charts, which is kind of disturbing to us because he has to sign off on kind of what his response would be to those results. And then he was saying, well, I have a huge practice, but someone should have taken the extra time because I think the nurse gave a deposition by video.
That's right. She
Yeah.
did.
So the nurse nor the doctor took the time to reread the standard template that goes out to all of their patients. So that to me was a big piece for us as the jurors that they did not take the time to read it and acknowledge until later when there were legal recourse that they kind of said, okay, we realized that it was an error. So that was a big piece for us as a juror that there was just a huge major oversight on both the cardiovascular group and Dr. Friedland.
The defense tried to argue or make the point in opening that it was a typo and that the letter was accurate except for that one word no. And just for our listeners, the letter said that there was no significant calcium buildup in your arteries, when in fact there was very significant calcium buildup. And the word no fundamentally changed the meaning of the letter. But what was your reaction when the defense made that sort of position in opening statement?
We weren't supposed to talk about it, but we were just like, wow, did you see that?
Yeah.
It was, I think, them being very dismissive of it. And I agree with you that it changed the overall intent of the letter. And then their response is, well, we attached the results, but the average family are not that much of medical experts, unless you have a family member that you can call and say, hey, look at these results. But for the average person, we're going by that cover letter.
Yeah.
And their response was, well, we attached the report. So the burden was on the family to interpret what those findings were. So we just felt that was a very poor excuse for responding to that no in the cover letter.
Well, shift a little bit and talk about Dr. Venkatesh. He was the colorectal surgeon, for our listeners. He was the colorectal surgeon. And the criticism against Dr. Venkatesh was that he knew that Mr. Yarbrough was sent to him as a referral from a colon surgeon because a colonoscopy showed that Ron had a big mass in his colon. It wasn't obstructing his colon or blocking his colon, but it was a big mass and it could be cancer needing to come out. And the surgeon, Dr. Venkatesh, knew that Ron had a cardiologist, and he knew that Ron had a number of risk factors, but did not get cardiac clearance and said he didn't need cardiac clearance. Talk to us about your specific reaction to some of those arguments, Angela, and kind of how that issue cut for you.
Well, we felt that Dr. Venkatesh should have bear some of the burden because, again, as you said, his medical records demonstrated the history of Mr. Yarbrough. So as a surgeon, the burden should have been for him to either pick up the phone and call, and that just never happened.
Mm-hmm.
So the lesson learned was that we had to hold him accountable as well as the cardiovascular group because that was surgery. He knew his cardiac history, and that the burden should have been for him to either pick up the phone, call, or do some additional follow-up to make sure that he wasn't as a higher risk for the colon surgery. So that's why we held him liable as well. A lower percentage, but we felt he had to carry some of the burden as well. And there was a lot of deliberation around that.
Let's talk about the deliberations. I'm curious. So you go back, this was about a week and a half trial. You come back over the weekend. I think we have closing arguments. I want to say we had closing arguments on Monday, a little bit more testimony on Monday. I think the defense called Dr. Friedland for a second time. Do you remember he testified a second time?
Yeah.
It seemed to me that Dr. Friedland, at least I try to make this point, was changing his testimony from where he had testified before. Did that come across to you as a juror that he was trying to sort of backtrack a little bit on what he had testified earlier?
I didn't pick that up. I thought we weren't really sure why he was called back.
Yeah.
But I guess you guys knew because of all what he submitted in his deposition or whatever. But I didn't catch that. I was just wondering why he was called back again. But both sides did a great job in asking the questions that you needed. But I didn't pick that up, that he was trying to change it,
Was there a point during the evidence, and we'll get to the deliberations next because I know folks want to hear about that, but was there a point during the trial where you went from being neutral, not knowing who's right or who's wrong, to, okay, I'm convinced now, or this seems very strongly in favor of the plaintiff's side? Was there a point in the evidence that you were like, okay, I get it now?
Yeah, I think we kept going to, because all of us took notes, pages and pages.
Y'all were good note takers. I saw that.
We kept going back. Everyone, regardless of your posture or position, was the standard of care. We kept asking that question, standard of care. So I think that's what resonated with the entire jury was the standard of care compromise. So that's what kind of stood out for us, when we went to deliberation, was just the standard of care.
And what led you to conclude? What's the single fact that you heard, the piece of evidence that made you conclude that the standard of care, let's start with the cardiologist, had been violated? Is there a single piece of testimony or evidence that was that landed with you to the point where you're like, okay, yeah, I get it. He violated the standard of care?
The electronic records and the doctor follow-up, the cardiovascular group follow-up.
The letter?
Yeah.
We had made the point and brought into evidence that after Ron died, Glenda was going through her husband's personal effects, his paperwork, and she came across the letter that had the so-called typo saying that his calcium score was fine. But of course, now her husband's passed away from heart-related issues. So she does look at the attachment and starts reading the report. And Glenda had a little bit more medical knowledge. She had worked in a doctor's office years ago. And so she reads the report, and she does see the report seems inconsistent with the letter. And then she calls her friend and shares it. And her friend's like, yeah, this isn't right. So Glenda decides to order her medical records. And I had made the point at trial that she ordered the medical records from the cardiovascular group, and then cardiovascular group sent her Ron's medical records, but the records did not contain the CT calcium report or the letter. And in fact, the record said, and the cover sheet said, these are all the records. We've provided everything. What did you think about that evidence, and how did that affect your view of the case?
That was a major piece that was very telling for us as the jury, because the comparison that was presented in the courtroom is that the medical group was not being fully disclosing of information. So
Hmm.
that played a pivotal role in our decision with the court decision, with the deliberation, that we felt that they probably felt that the family was going to seek legal counsel. And we felt, in our opinion, that they were intentional with not sharing the full medical records of the patient.
I had used a slide during closing, what I called the web of deceit, and I showed a big spider web, and I showed the, holding back the records, no mention of the CT calcium score in the chart, providing a stress test result that was older and was normal, showing that they could produce test results, but they didn't produce the CT calcium score. I heard some people comment that maybe that was too much or too aggressive. Do you have any comment about that? Or do you remember what I'm talking about?
Yeah, I recall the presentation. I think what was really telling is when you showed the difference from the medical requests, one
Mm-hmm.
side versus what you ultimately received. And that was very, very telling to the jury.
Mm-hmm.
But yes, I do remember the analogy that you presented.
I wasn't sure if that landed or not. I mean, the defense didn't really offer an explanation for why the records were certified as complete and they were not complete. I mean, their only explanation, or their only kind of, it wasn't even really an explanation, but their only response was, well, we produced all the records later. It's like, well, how's that helping your cause? But
Yeah, very deceitful.
yeah, that was my impression as well.
The letter with the no in it, and then the electronic records, because he received the information. It was how he shared it with his patient. And this is a patient of 20 plus years. Even though they tried to say that, oh, he wasn't coming to us consistently, but they knew the history of this patient. And
Hmm.
the family has been going to him for years and spoke very highly of him, you know, throughout
Hmm.
their years of care. But it was just, the electronic records were there, black and white. And even the nurse said that was, and yeah, it said it, but there was an error. Because I think they even talked about the testing, the electrodes were reversed or something.
Hmm.
Was that with the calcium test? I think that's what they were saying. And that's why one of the results showed something. But I think that was when he went into surgery, though.
Yeah, yeah. There's a lot of medicine thrown at you guys, but what about the colorectal surgeon? Was At what point, what piece of evidence convinced you that he had violated the standard of care?
The next day after surgery, when I think he had a heart attack the day after
Hmm.
the surgery.
About 2 days, but close
Yeah,
to 2 days. Yeah.
yeah. So what resonated with us was that, again, the records, I think they did put it in his medical records that he had a surgery coming up.
Hmm.
So that stood out to us, that, standard of care was not maximized in
Hmm.
this case, because he did go for an ER. Records are there. I'm sure they sent something to the cardiovascular group, but that stood out for us with the colon surgeon, was just, again, the standard of care, and then knowing his heart cardiology history in the patient records.
So take us to closing arguments. A number of hours sitting there, listening to lawyers make the case, argue the evidence. Start with my closing argument. If there's anything that stands out to you, what stood out to you? Then I'll move to the defense side.
What stood out with you? Well, we just thought you were just, oh my goodness.
Is that good or bad?
Did a great job. We were just
Oh, I
like
appreciate it.
high-fiving, like, oh my goodness. Everyone said, if we have any medical issue, we're going to Lloyd Bell's first.
And just for the record, I did not pay you to say that, but thank you for that. But because you can't really tell. I mean, y'all have great poker faces.
Really? I mean,
Yeah.
everyone said unanimously, if I ever, any family member, we're going to Lloyd Bell's law
Well, I
firm.
appreciate that. I really do. Was there anything substantively about the closing that was helpful or harmful, or
I think you're summarizing the facts for us again. I keep going back to how you plain language all of these medical terms that
Hmm.
the average person didn't know, and how you plain languaged it. Your exhibits absolutely helped us a lot.
Which one stood out to you? Do you remember any of them specifically?
The one with the timeline. Oh, that
Hmm.
just really, really, I mean, your timeline, they even used your timeline.
Yeah.
So your timeline really, really stood out to us. And then the actual exhibits of the artery, you had the,
The models, you mean,
yes,
or
yes,
yeah, was that helpful? Yeah.
yes, the
Yeah.
models. So definitely that timeline, we kept going back. Did you see his timeline? And it showed it from cradle to grave,
Hmm.
everything of the Yarbrough case. So that timeline, having it blown up, and then you had your iPad. I guess it was an iPad. It
Hmm.
populated it on the screen. So all of your assisted technology and that exhibit with the timeline, we kept going back to that when we went to deliberation. So that was extremely helpful.
Did you write down the data points from the timeline?
Yes.
So all that was in your notes to go right back to.
Yes.
What about the defense closing? Did anything stand out to you on the defense side? There was Dan Huff, was the cardiology lawyer, and then Heather Miller was the defense lawyer for the colorectal surgeon.
Yeah. We were surprised that Huff, is that her name? Hef?
Heather Miller was the woman attorney who represented the colorectal surgeon, Dr. Venkatesh, and Dan Huff
Yeah.
was one of the attorneys, but he did close an
Yeah.
argument.
We felt like the colon legal team really could have done more, but
Hmm.
they were not as vocal. And we were like, we didn't understand why, because he was being held liable as well. So we felt that they could have done a much better job than what they did.
Hmm.
They really didn't do a lot to defend him. They were just more accusatory, asking a probing about, okay, well, how much did you pay this medical person? Instead of focusing on the facts of, why my client should not be held liable. They spent more time focusing on kind of attacking the medical experts and kind of being retaliatory to the facts,
Hmm.
instead of like really focusing on the facts of why the colon surgeon should not be held liable.
One of the facts that came out when they were cross-examining Dr. Cohen, they were asking him a lot of questions about how often he testifies, how many different states he testifies, how much he gets paid, and then I brought out that he had worked a lot for these defense lawyers, or at least their law firms, including Mr. Huff and his law firm. What was your reaction to hearing that? Did that land? It felt like it did, but what was your reaction to that?
Yeah, we heard it, but we were like, okay, that's what medical experts do.
Right.
They work for various law firms. There's a vetting that's done on either side. So
Hmm.
to me, it didn't really raise it. It was just how the medical experts presented the case. So that's what stood out to us.
You mentioned earlier, I think, that there was some comment about how much Dr. Levy was charging and how much he gotten paid when y'all went back to deliberate. Talk to me more about that. How did that impact or affect the view of the case?
Well, we all joke that we're in the wrong profession. Number one.
Everybody should be a legal expert
Yes, yes.
or a medical expert.
We kind of felt that's just part of how these cases work. You have to have the best medical expert to present your case. So, again, we felt that your medical experts just presented a better case.
Mm-hmm.
You came prepared with your exhibits, the visuals, the way you explained it, you plain languaged it. It just was just unanimous that all of us said that you prevailed and you came prepared for that case, because the case, it looks like it was a few years ago. The case was filed.
Yep.
So why didn't they come with their A game on
Mm-hmm.
court date? And that's how we just felt. I think the part for us was deliberating was the dollar amount. It
Mm-hmm.
wasn't that, they did a great case. It was just, the evidence proved itself and you presented the evidence better than the other attorneys. And that's how we kind of deliberated.
I want to go back into the deliberation room with you. You've now heard closing arguments. The judge is giving you the instructions, the legal instructions. She's sent back copies of the instructions to everybody. Walk us back into the deliberation room when you first get back there, and the exhibits have arrived, so you can get down to work. What happens? What do you do?
We were trying to figure out how to monetize, because I think there were three areas. One was,
Pain and suffering,
yes, pain and suffering.
and then the wrongful death, and then
Yeah,
and then the medical bills.
yeah, the medical bills. So unanimously, we all said the medical bills had to be paid,
Mm-hmm.
periods. So that was I think it was $1.7 million.
Mm-hmm. That's right.
So maybe two or three said, well, he's retired, he's disabled, he has medical insurance.
Mm-hmm.
Insurance is going to cover, and it's really not actually 1.7 million. And
Mm-hmm.
so we had to spend time going back and forth about it doesn't matter. The
Mm-hmm.
records that was presented to both sides show that it was $1.7 million. So the piece about the pain and suffering, we were back and forth, and wrongful death. So we had to do a lot of calculations, reviewing the documents. And that's how we ultimately landed on the amount, because the lives lost, some people felt like, well, he's over 60. He
Mm-hmm.
has a medical history. He was going to die anyway.
Yeah.
And yeah, we were like, no, you can't use that. We have to go by the facts. This man lost his life because of standard of care was compromised. So we spent a lot of time, even went beyond lunch, just going
Mm-hmm.
back and forth, and no one would yield. So we had to basically compromise on how to monetize that amount. Because I don't think you guys knew we had to break for lunch and then reconvene to deliberations.
We were told that. I think we were told y'all had gone to lunch and then came back. I want to get a little more granular though. So when you first got out to deliberate, you're in the room. Now, have y'all developed friendships at this point? Had y'all, I mean, what was your feeling towards your fellow jurors? You spent a week with them? Had you gotten to know their backstories, what their families, did y'all get to know each other like that?
Yeah, we didn't learn a lot about each other personally, but we just
Hmm.
talked a lot about our opinions on the case.
Did y'all get along with each other? Did y'all like each other?
Yeah.
Sometimes jurors don't. Sometimes they get in there and they just rub each other the wrong way for some reason. They're people.
Yeah, we had two that were pretty silent, quiet,
Mm-hmm.
and I think part of it was kind of the language barriers.
Mm-hmm.
But one of the other jurors was interpreting and explaining it to them,
Mm-hmm.
in their language. And then maybe three felt like this is a lot of money.
Mm-hmm.
Regardless, we should give them nothing. And we were like, no, we're not. We're going to award this family what they truly deserve. And then it was like, and the attorney's going to get most of the money. So it was just a lot of back and forth,
Mm-hmm.
about it. And ultimately, the family won't get anything. So people came in with those preconceived notions. And then, we said, okay, let's get back to the facts. And
Mm-hmm.
that's how we start pulling out calculators, trying to
Mm-hmm.
figure out what's a fair and reasonable amount.
Mm-hmm.
And then a few held out, and it was like, okay, so if you can convince me, and we had to do actually hand counts. Okay, who's voting this way? And we had to kind of recalculate numbers, and that's how we ultimately ended up with the multi-million dollars amount.
How did y'all decide liability? In other words, was there an argument about whether there should be a verdict for the plaintiff at all? Is there anybody who believed that there should be a defense verdict?
No, none.
Was there anybody who said let Dr. Venkatesh off the hook or let Dr. Friedland off the hook?
No, no. We were trying to figure out what percentage would each be held liable for.
You had the verdict form. Did you approach it in the same order that was on the verdict form? Like this is
Yes.
question number one, this is
Yeah.
question number two.
Yeah.
Okay. That
Yeah.
and how did y'all pick your jury foreperson?
It was between me and the gentleman that was the foreman.
Mm-hmm.
And I told him I'm indifferent. It does if you want to get that experience. So that's how we ended up with the gentleman being the foreman.
I mean, were you all nominated by your fellow jurors? Would somebody say, Miss Banks, you've done this, Angela, you've done this before. Why don't you be the foreperson?
Yeah, the bailiff pulled us in and said, "Okay, before you guys get started, make sure you identify a foreman." And
Mm-hmm.
so they were like, "Okay, who wants to do it?" I said, "Well, I'm willing to do it, so I can, facilitate, because that was the
Mm-hmm.
role, is to facilitate the discussions."
Right.
And then the gentleman said, "Well, I'm interested." So I said, "Okay." So it was, they said,
Mm-hmm.
"If you want to do it, either one." And that's how we kind of landed with him being the foreman.
Well, how would you describe the job he did?
He was a little nervous.
Yeah. Yeah.
So we had to prompt him, "Okay, let's keep moving." And so we went literally by the instructions on the sheet to land with our deliberation. So we went question by question.
And you said that y'all dug into the records and dug into the exhibits. What did that look like? If we were standing in the room
Woo.
with you, watching what you were doing, what would we have seen?
You would have seen us passing along because you guys brought in like crates of stuff.
Yeah, we did. A lot
It
of
was a
records.
lot of voluminous amount of information.
Mm-hmm.
So we actually went through the medical costs first and saw that, okay, these are valid, legitimate expenses. And someone went through with the calculator
Okay.
and came up with the 1.7. What else did we go through? I think that was the major one that we went through. And then we just started going through the questions and looking at our own individual notes. So that's what we did.
What was the group dynamic starting off after you picked the four person?
So the group dynamics, we went through like the first question, and then we just started voting. We was like, okay, having conversation. It was very conversational
Mm-hmm.
and very opinionated, but we went through every question and made sure that everyone understood the question, and then we voted on every question.
You say very opinionated. Give me, and I want to respect your fellow jurors and not call anybody by name, which we haven't been doing, but give me a sense of the strong opinions on all sides that you remember in the deliberations.
I remember two of the gentlemen saying, well, we just need to award them
Mm-hmm.
medical only, because he's retired, he's disabled vet, he could never have this type of income, or the family couldn't have this type of income, even if he was living.
Mm-hmm.
And so we had to argue and say, we have to exercise some
Yeah.
compassion for the family. This man has lost his life. His wife no longer has a husband. The kids no longer have a father or a grandfather. And
Mm-hmm.
so we had to make sure people show some compassion for the family that has to live with the loss of their family member. So
Mm-hmm.
that's what kind of led us to come up with the wrongful death suit. I mean, the wrongful amount, and then the pain and suffering. Then we calculated it in its totality to come up with the final dollar amount. But it was a lot of nudging,
Mm-hmm.
a lot of nudging.
The first questions dealt with liability. We find in favor of the plaintiff and against Dr. Friedland and Dr. Venkatesh and/or Dr. Venkatesh. And you obviously found in favor of the Yarboroughs against these two defendants. Was there anybody on the jury who disagreed that these doctors were liable, that were in favor of a defense verdict?
No.
Okay. So y'all got through that question pretty quickly then.
Yep.
And then tell me about the discussion about percentages of fault between the two. And just for the listeners' benefit, I had argued that most of the responsibility should be on the cardiology group because Dr. Friedland had the most opportunities to change the outcome. And I argued that Dr. Venkatesh should be liable. I think I argued for 80% cardiology, 20% on the colorectal surgeon. And then I don't think the defense offered any alternative percentages. But how did y'all approach that? And tell me about the opinions in that regard.
So the jury said, well, we hear what Mr. Bell, the Bell law firm said 80-20, but let's revisit it. And that's when we kind of broke it down that we felt that Venkatesh had to have some ownership of what
Mm-hmm.
happened because the man was in the hospital for over 30 days
Mm-hmm.
and he knew the history. So we were back, I think we were going to do with 40%, then 25%. They didn't want to go with what you recommended, but we were trying to get somewhere close to it. And
Mm-hmm.
that's where we had a lot of conversation, you know. And some of them felt, well, you know, he has cardiac history. They said it ruptured. And we were like, let's go to the facts, you know, because they was like, in my opinion, he was going to die anyway, you know. So that's how we ended up with kind of going with the 30% because Venkatesh had to take some ownership of it. And we
Mm-hmm.
felt like the attorneys representing him should have been more vocal in representing him, but it just did not relate to the jury that they were defending him as much as they should have. And it showed with the verdict.
How long did it take to answer the question on percentages of fault? How long did y'all deliberate on that?
Oh, at least an hour, I'm thinking. I didn't really time it, but
No, but just your sense of it was that it was pretty lengthy.
yes, yes,
Was there a anybody advocating 50-50?
no,
So it was always more on cardiology, but the
yes.
debate was there anybody who was as low as 90-10? 90 on cardiology, 10 on Venkatesh.
I don't recall being that low.
Okay, so
The issue was unanimously that the cardiovascular group had missed opportunities, that the
mm-hmm,
outcome could have possibly been different had they paid attention
mm-hmm.
to the patient's records.
And then the big question was, okay, you decided faults, you decided percentages, and then the big question is, well, how much money to put into the verdict, how much to include in the verdict. Tell me about that. Tell me about those discussions because it seems like that's where a lot of the heat was.
So they wanted to go to the judge to ask what percentage goes to the attorney because that was
Mm-hmm,
their big thing. Well, the attorney's going to make the money. And I said, I don't think that's a appropriate question to ask the judge. So we
mm-hmm,
spent about 30 minutes debating. Should we ask the judge what percentage of the award goes to the attorney?
mm-hmm.
Because that was a sticking point with at least half of the group.
Interesting. Interesting.
Yeah.
What could I have done potentially to lessen that concern? If there had been an instruction that you are not to concern yourselves with, I mean, whatever. I mean, all the attorneys, of course, get paid.
Right.
It's business, obviously,
Right.
so at that level. But is there anything that could have reduced that concern in your mind?
I'm trying to think because you were pretty well. You all were pretty deliberate on how we should calculate. You know, medical. You know, pain and suffering.
Mm-hmm.
So attorneys' fees never came up, but you know, we couldn't Google.
Mm-hmm.
Phones were taken away, and I was
Mm-hmm.
just telling them that generally, in most cases, it's negotiated with the client and the
Mm-hmm.
attorney. And in most civil cases, it hovers around 30 to 40%.
Mm-hmm.
So people were basing upon kind of what they felt it would be. And so we ultimately decided to kind of not ask that question because we didn't know if that would kind of taint them
Mm-hmm.
saying you're going to be dismissed as a jury. So we just didn't know. We just kind of winged it and just
Mm-hmm.
went back to kind of what we should award the family.
What was the range, without mentioning anybody's name? What was the high end that people were talking about or advocating for? I think you told me the low end was zero. Some people were saying, let's don't put any money in the verdict,
Just do the medical.
just the medical.
Yeah,
How many people were on that side of the zero side or just the medical side?
probably 5% because everyone was like, are you serious? Just the medical?
So just a
Because
couple of people were like that.
yes, yes. Yeah.
And what was on the higher range? What were some of the numbers that people were talking about on the high end?
I'm trying to remember what you were proposing.
I proposed $1 million a day of pain and suffering,
Yes.
and then $1
Yeah.
million a year for wrongful death.
Yeah. And we had discussions about that, and we were like, we're going to have to negotiate. I felt it was fair and reasonable, but some of the
Mm-hmm.
jurors was like, no, because had he lived, he could never have had that earning potential living.
Mm-hmm.
So, we talked about kind of the legal experts. There's expenses with that, travel, and just preparing for a trial like this is
Mm-hmm.
expensive because most people try to settle before
Mm-hmm.
they go to court. So I told them, I was like, hey, you guys, I'm pretty confident that they wanted to or tried to settle out of court and couldn't reach a decision.
Mm-hmm.
So we're going to have to be fair in what we do as a judgment because the attorneys do have to get paid and
Mm-hmm.
the family should receive something as well. And it was a no-brainer about the medical. So it was just a lot of back and forth about that, how to quantify what to give for pain and suffering, and wrongful death. So
Mm-hmm.
we were back and forth doing calculating. We used your number as kind of a idea of what
Mm-hmm.
to award, but ultimately landed with what the dollar amount that we came up with.
Do they have calculators back there for y'all to use uh,
Yes.
in the room? Okay.
Yes.
Was there anybody? Were there any whiteboards where people could get up
Yep.
and write?
We definitely had the whiteboard.
Were y'all using some of that?
We were using the whiteboard to calculate everybody's responses. So yes, we went
Mm-hmm.
line by question on that form.
Interesting.
So who created that form? The attorney or the judge?
It's actually pretty collaborative. We each side kind of get together and we try to get the form correct, and then the judge approves it. It's committee, almost by committee, but we always want to make sure that's accurate because that could create problems on appeal.
Yeah, very, very helpful, extremely helpful.
When you finished jury service and you were excused, as you are now, of course, did you talk to anybody about your experience? Just anybody say, what was your experience like? Did you mention it to your family members or your daughter or that you were on a jury? Did you share any of your experience with anybody?
Yeah, I shared it with my siblings because I'm a family of 10, and I told them how it
Oh.
resonated similar to our sisters. So I said, I'm going to try to follow up, just getting a legal opinion, because my
Mm-hmm.
sister had similar cardiovascular issues,
Mm-hmm.
the colon thing. So I told them
Mm-hmm.
that I'm definitely going to follow up. And I think maybe it was intentional for me to be on the jury to just hear the facts of the case. So
Mm-hmm.
that's what I share with my siblings. So that's what I plan to do.
What? Well, and as far as your overall experience, now you've been on two jury trials. How would you compare your experience in this trial with the first med mal jury trial you were on?
This one was a little more detailed because when we went to deliberation, they didn't give us all the documents, like how you had all the medical files.
Mm-hmm.
We didn't have that. We just had our notes, and we were in a smaller deliberation room.
Mm-hmm.
So we don't understand. I didn't understand how it was different, and it was still a malpractice case. And I'm
Mm-hmm.
trying to see. I guess because you had, in this case, there were two doctors. Well, there were multiple doctors on that case as well. But that's what resonated differently with me is
Mm-hmm.
they didn't take to the deliberation room all the the cases of information.
Yeah, yeah.
We didn't have the level of questions that you guys had on the previous case. So
Mm-hmm.
now I understand it's by committee action. So maybe those attorneys didn't do it that way.
How would you describe your overall experience in terms of? I mean, it's a week and a half out of your life. It's pretty demanding. Sit there for hours and hours and hours listening to lawyers and doctors and judge. How would you describe your overall experience being on this jury?
I felt it was very rewarding because the facts were presented. We got to know the family members personally through them serving on the jury and friends. I think it was family and friends. I think it
Mm-hmm.
was.
Yeah.
And it was very impactful, that, we played a major role in kind of bringing some type of resolve for the family.
Hmm.
So, in my opinion, I felt it was very rewarding, and would love to meet the Yarbros one day, because
Lovely people.
we just met them just in the courtroom, but just to know how they're doing,
Hmm.
after the loss of her husband, because they've been married for years.
45 years.
Yeah. So, in my opinion, I felt it was just very rewarding, and I'm hoping we made an impact to the family because it seems like it was multiple years of litigation
Hmm.
to kind of come to some resolution to the case.
You've been a wonderful guest, and I appreciate you sharing your insights. This is sort of like peeking behind the curtain for the lawyers because we spend a lot of time and a lot of energy trying to decide how to select jurors that'll be receptive to our case, how to present our cases, and it's just very helpful. And I know it'll be helpful to the lawyers who listen to this podcast, who are trying to be more effective as advocates for their clients. So thank you so much for your time today, Angela, being with us and sharing your insights. And I will look forward to hopefully staying in touch in the future and let you know how the Yarboroughs are doing. And just want to thank you again for all your help today. This has been great.
Thank you. It was an honor.